And welcome to a new discussion from the IFTA Connect series, where we share and discuss business insights, trends, and opportunities affecting the global film industry. And my name is Robin Burt. I'm the Vice President of Marketing and Membership for the Independent Film and Television Alliance. I'm pleased to introduce our guest speaker today, Schuyler Moore, who is a partner with the law firm from Greenberg Glasgow, to discuss what you can't use in your movie. There are several categories of laws that impose important limits on what you can include in a film, and it is important to be aware of these categories, the difference among them, and the limits for each one. Schuyler will provide practical information, explanation, and examples of these issues. If you have any questions for Schuyler, there is a Q&A icon at the bottom of the screen, and he will get to as many as his questions at the end of the session. And without further ado, I hand it over to you, Schuyler.
Thank you so much. The topic today is really what you can't put in a film, which to get you in legal trouble. And I've seen way too many. My goal is to keep everybody out of litigation, because litigation is not fun. And there's a lot of rules that go with it, and a lot of ambiguity and a lot of confusion. Let's just say that people have misunderstanding of what you can and can't put in a film. So with that introduction, and by the way, I'm going to take all the questions that you have at the end. I will stay as long as it takes to answer them. And often that's the most fun at all. You know, people ask fantastic questions. And so I'm going to absolutely go through that. The first thing that I want to discuss is the concept of what I call stolen ideas. And that is ideas that are not yours, that you heard from somebody else one way or another. And I'll give you several different examples. The one is a film company asks somebody to come in and give a presentation on a particular subject. They either heard about it, the person wrote in, and the film company calls them in and says, come on in, tell us your idea. Or send in your submission, and the person, and they're asked, and this is the key, they're solicited, they're asked to either come in person or to send in their idea, and they do. And if that happens and the film company then steals the idea, so, and you know, you guys could be on each, the people watching this could be on either side of this. You could be submitting the idea, or you could be the one getting the idea. Whoever when it now receives the idea, runs off and makes the film, and obviously doesn't pay the person that submitted the idea. And this happens all the time. This is a very, very common fact pattern in Hollywood. And the question is, okay, what are you allowed to do that? And the answer is no. And you will, the person who has submitted the idea will sue for what's called implied in fact contract, that the mere request just from somebody to submit an idea itself creates in law, by the courts have held, a contract that requires that person to pay the fair market value of whatever it is that is submitted, if it's used. So film company asks somebody to come in, or they ask for the idea, person submits it, film company does it, they will get sued for implied in fact contract, and the film company will lose. So don't put in your movie, this is what not to put in your movie, an idea you've solicited and that you have not paid for, all right? Because that, or you have not, don't have a contract for. The more common problem is not solicited. And this comes up, this again, Hollywood all the time. People send in submissions all the time. And they tell their friends at lunch, hey, I've got this fantastic idea. Or they, you know, any number of ways people submit ideas that are not solicited. And the person that receives the idea says, my God, that's a great idea, I'm gonna go do it, and they go do it. And they don't pay for it. The question then is that allowed? And the courts don't find that there's an actual contract. They will not find that there's an actual contract. If the submission was oral, if it was you know, over lunch, it was over a meeting, most courts will not permit a claim for will not enforce a claim by whoever submitted the idea. They will generally lose. However, there have been a number of cases where people have won on the concept of misappropriation, conversion, various tort theories where they have been successful in making a claim. And so I would, if I was a film company and someone submitted that idea, I would be very cautious about that. Generally I would not use it, even if it is not solicited and it just comes in over lunch or whatever. You're running the risk of a claim, and to be sued is to lose, because whether or not you win or lose the claim, or the law, if you're defending it, it's very expensive and it's painful, and so you really shouldn't do it. One oddity on this comment is that a lot of film companies say you have to submit the idea through a lawyer or an agent, and I never understood that, because so a client gives me a script and asks me to submit it to a film company, and let's say I don't know why the film company takes comfort in that. I don't understand that, but many film companies, for some reason, say it has to come through a lawyer or an agent. My experience on that, by the way, is that that's just a kind way of them saying don't bother, because I've never had a film company accept, and my clients of film companies would not accept just because it came in through a lawyer. It's going to go right into the trash bin. So I don't understand that, other than a nice way to say no thank you. If that submission was in writing, and this is the key difference, then you're going to have a copyright claim. So this is why it's so important, if you're submitting an idea, for God's sake, put it in writing, because you will now, even if it's not solicited, and if you're the one submitting the claim, submitting the idea, and the film company uses it, you will have a very solid copyright claim. You don't need to register it. You just need to put it in writing and prove that you wrote it before you send it. Well, if you send it in, you send it in writing, and have proof that you did that. And now we're going to go. So now we're going to go to copyright. And so the next thing that you can't put in your film, other than stolen ideas, the next thing you cannot put in is material that is protected by copyright, that is owned by somebody else. And copyright means that it has been recorded in some kind of tangible medium of expression, in writing, a book, a movie, a recording. It's been somehow or other recorded in some tangible form. Your short answer is don't use copyrighted material in your film. And that's leave it out. I mean, that's the safe answer. Many people want to use other copyrighted materials a little, sometimes briefly, sometimes not. Sometimes they want to change the idea. So I will give you the technical rules, and then I will tell you what's actually happening in the courts. First, technically, before you get to defenses, any use of copyrighted material is a potential claim. So even a quick snippet of a clip from some other film, or some picture, or some whatever in your film, gives a potential claim, and that's called direct use. So if you've taken a clip from a film, or a picture that you see, or a whatever, and you have even briefly put it in your film, that's direct use. That's a potential claim. We'll talk about defenses in a bit. The more interesting one is indirect use, where it's not exactly, you didn't take a clip, you didn't copy it, it's not the photo, but you did something similar, right? You did something that's kind of like that. You took an idea from one film and changed the storyline a bit and made your own, but kind of followed the storyline. Or a famous one that's going up right now is Andy Warhol took a photograph of Prince that was made by somebody else, and he did his thing, which is colorize it and change it a bit, and that's and then sold his art, and that was an indirect use. Those are generally called derivative works, and as opposed to a direct use, something that is like the original but not exactly is a derivative work, and that's also not allowed. That is, you by using a derivative work will cause a claim, will give a claim to whoever the copyright owner is. Now let's talk about, and by the way, this is even a very short, very quick thing. If I'm in a film, I'm going to give you an example. If you're in a film, and let's pretend I'm in a film, and you see a picture in the background, and there's a picture there in the background, and if you can see it, even briefly, if somebody could make out what it is, that's a copyright claim. And by the way, that is a picture that I did, and that, so it is, I would have a copyright claim against myself because my wonderful picture appeared in the background. Even that fleeting, and now we get to, okay, so now you have a claim. Now the question is, what are the defenses? The first defense is, hey, my work is so different, it's nothing to do with the original. So I didn't use the original. I didn't do direct use. I didn't make a clip, a copy, whatever. And what I did was so different that it just wasn't that. And so, you can't sue me. And if the facts are true, fantastic. Now you're okay. That's a good defense. Another one is, hey, I did it on my own. I didn't even see that one. I didn't know about it. And I'm so clever. I came up with this idea myself. And gee, it happens to track my film looks exactly like Jurassic Park, but that was coincidence. I never saw it. That's a great defense if you can prove it. And what they generally want to show is that you did not have access to the original, and you never saw the original, never had access. That's, and on my Jurassic Park, they'll say, hey, really? Like that, I bet you saw that film. And a lot of cases turn on that. Now the big defense that you hear all the time is fair use, fair use, fair use. Hey, see that clip in the back, that picture, it was only there for a short period of time. It's fair. Or Andy Warhol says, hey, my painting is, I know I took that photo, but I changed it, and therefore it's fair. And the fair use statute, when you get done with it, all it says, it's a ridiculous statute. All it says is what's fair. It has a lot of factors, and sometimes you can, go through them. And what's interesting is that the courts typically ignore the factors, and they have come up with this strange rationale on whether or not the work is, quote, transformative. And if it's transformative, then it is permitted under the fair, it is allowed, you're allowed to do it under the fair use defense. I will tell you now the truth of what's happening. And the truth is, without question, courts are ruling with their hearts. And what they do is they look at the two things. They look at the original work, they look at the new work, and they say, what do I, the judge, think? And if I think that it's too close and I'm bothered by it, then I'm going to hold that it's copyright infringement. And if I think it's too far apart, then I'm not. And I'm going to, and the truth is, the opinion should be one sentence, and it should say, I've ruled with my heart and I think this is okay. Or I've ruled with my heart and I think this is copyright infringement. That's all it should say. But unfortunately, what they do is this long-winded theoretical rationale, and they get themselves in trouble because they use a lot of silly words that end up, they have to explain in a later decision. And what you will see, that the analysis goes as follows. If they think it's infringing, the wording will be as follows. One, it will be, I think this is either a direct use or substantially similar to the original. They'll use, so if it's direct use, it's obvious. If it's indirect, it'll say, I think it's substantially similar to the original. And then if they think that the fair use defense does not apply, what they will say is, and therefore this is not transformative, and therefore it's not fair use. And then they'll give a lot of rationale and they'll go through it. If they think that what you did is okay, then they will say, well, it's either not really substantially similar to the original, or if it is, it's transformative, and therefore it's fair use defense. And then there'll be a lot of words that they will try to have to rationalize it later. The case to keep an eye out on is there's going up to the Supreme Court right now, the Andy Warhol case that I mentioned about Andy Warhol doing a colorizing a picture of Prince, and the Second Circuit said that it was not fair use, and it did, the normal rationale. It's, oh, this is substantially similar to the original, and it's not transformative, and therefore it's infringement. And the Supreme Court has indicated it might say use the other words, because who knows what, maybe they like the Andy Warhol print. So this is the short answer for your film is leave it. If there's any doubt, two things. One, if it's direct use, don't do it. And don't there's no 5-second rule or 30-second rule or whatever. There's just not. You never know. There's some cases that have held infringement on very short use. There's no guidelines. There's no rules. I get this all the time. Oh, Sky, can you give an opinion on this? And the answer is no way, because my opinion will say, yeah, here's my opinion. Looks good to me, but what do I know? Who knows what a court will do? And because there's no guidelines, so which is really a problem. So that's kind of like, leave it out. So that's I don't know what that's really the guiding rule. Unfortunately, is copy. The other thing that you can do, which I also suggest, is you can go to people and you can try out whatever it is you're going to do, and ask people if they think it's fair, and just say, hey, do you think this is okay? Like, I'm going to do a script that looks like that, or I'm going to do a picture that looks like, and if you get a lot of people that say, I think that's fine, then you're probably okay. That's probably going to hear that the court will do fair use defense. But if you hear a lot of people saying, I don't like that, then I can guarantee you the court's going to go the other way. So there's the non-technical rules for copyright. Courts will rule with their heart. Next, what you can't put in your film. This is kind of a crossover. I'm going to talk now about trademark, and because this is sometimes you can and sometimes you can't. Trademark is like Coca-Cola can, or the Apple iPod, or it's generally the name of a company or their logo or their mark. And the rule is you can't use a trademark in a way that is intended to confuse consumers as to the source of the good. So it's very different than copyright, and this becomes very important. So, for example, if I have a film, and I wish I had a product that I could show that was in trademark, but I don't, and I hold up a Coca-Cola can, that's fine, because I'm drinking my Coca-Cola in my movie. I'm not suggesting to the consumers, I'm not suggesting to the viewers of the film that, hey, this film was made by Coca-Cola. You should watch this film because Coca-Cola made it. No, I'm obviously just drinking a can of Coca-Cola. Similarly, if a Mercedes drives by, or if there's a Taco Bell in the background, or if there's a whatever, fine, that's not a problem, because the movie is not suggesting that the movie was made by those companies, and that therefore you tricked consumers into coming to the movie theater because they thought that because there was a Mercedes or a Taco Bell that oh my God, this movie is going to be great because it was sponsored or made by Mercedes or Taco Bell. So you're allowed to have trademarks in your film, and this drives me nuts, because the clearance services that most studios use do not differentiate between copyright and trademark. And the moment they see a trademark, they go, oh my God, you've got to take it out. And it's just not the rule. And they drive me nuts. You can have all the trademarks you want in your film. The only issue we'll get to is a different issue, which is trademark basically trademark defamation, but we'll talk about that later if you're portraying it in a bad light and claiming some fraud about it. So have at it with trademarks, all right? Those are things you can put in your film, although be careful about, the one thing you can't do is, or be careful about, is naming your film, using a trademark of some other company as the name of your film. This is why the film social media couldn't be called Facebook, because that could have caused if the film was called Facebook, it could have implied that Facebook was behind the film, either producing or sponsoring it. Also in advertisements, you have to be careful about not using trademarks in advertisements for the film, because there's a very special section called the Federal Anti-Dilution Act that does not allow the use of a famous trademark in connection with advertising. You just have to be a little bit careful about that. So advertising, you kind of be careful about including trademarks, but in the film, you're okay. Next, let's talk about people. Can you put other people in your film? Can you take a picture of somebody? Can you image? By the way, this has become really important because of artificial intelligence. You can now create, Brad Pitt, Tom Cruise, whoever you want. You can put them in your movie. Absolute deep fake. You can sound alike, look alike, walk alike. So this has become a very, very serious issue. And even apart from artificial intelligence, and this comes up in the metaverse and artificial intelligence, virtual reality, it comes up all the time, and even beyond the creation of new lookalikes. Can you use in a documentary? Can you take somebody's image that you saw? Can you in a film that you're making? Can you take people that can you view people that are walking by on the sidewalk? Short version is, there's a potential claim anytime anybody uses anybody's name, image, or likeness for any purpose. That is how broad this is the right of publicity. The prima facie case is very, very broad. It is not limited to celebrities. It is not limited to advertising, and it includes indirect use. And so a classic one is, there was a commercial that featured a robot spinning the wheel of fortune, and Vanna White sued and said, the public would have thought that that's a reference to me, even though it's a robot. And the court said, yeah, you're right, and gave her, and she won. So anybody can sue for any use, even an indirect use that kind of conjures up their name, image, likeness, something like that. So very, very broad. You're then down to the defenses. And so what are the defenses? I'm going to give you the most of the typical defenses. One is very short incidental use. The person just walked by the screen. I filmed a crowd at a stadium, and I could see individual people, but just briefly. So short incidental use. Next is coincidental use. This is so if I have a character named Joe Blow, and I get sued by a real Joe Blow, and I say, come on, I named my character Joe Blow because that was my creative decision. That will be a defense. So they can't, the real Joe Blow can't sue unless I used his name, unless I used his actual image. That would not be so good. Next, most importantly, we really get to the First Amendment. This is the freedom of speech, which is a misnomer, but there's a lot of protection protected by the First Amendment. The first is for any matter discussing a matter of public interest. And you can make any film you want about a matter that is factual, about a matter of public interest. And for example, and this is what I get this all the time, you read an article in a newspaper about some fantastic story and it's factual. You can go make your movie based on that story. You do not need to go pay the author of the article or the publisher of the newspaper or the life rights of whoever it is. By definition, if it's in an article in the newspaper, it's of public interest. It's free game. You can go make a movie about it and you don't have to pay anybody. And this drives me insane because I always have clients running around trying to pay everybody in the world to get what they think they need to get to make a film about a story that they read about. And it's like, stop, go make your film. So absolutely free to have at it, but it's got to be, again, a matter of public interest. Or about a person of public interest. I mean, if you can tell the private life even of a celebrity because that's a matter of public interest. And that's, by the way, how all the National Enquirers get away with it, is because they're relying on the First Amendment. Second is parodies. If you're doing a parody, that's First Amendment, that's protected. There's some cases bubbling up that might question that, but that so far that's the rule. But it's got to be a parody of the original work. You can't just take an existing copyright and do some other story that is, and even if it's funny, doesn't really kind of criticize or comment on the original. A parody is viewed as something that is commenting on or criticizing in some, usually a humorous way, the original work. And but as long as it's a true parody, then you're good to go. Some courts hold that the First Amendment protects all entertainment, expressive works, films. You can just do whatever you want. I think that goes way too far. I think that'll get sorted out. I don't believe that the Supreme Court will uphold that. Other courts have held that they limit this defense to works that are, quote, transformative. You hear that word again, and it's got to be. So if you have an individual, like this comes up again in right of publicity, some courts say right of publicity defense doesn't hold against some kind of work of art, movie, whatever. Some courts do that. Other courts say, no, it has to be transformative. And then the question is, what's transformative? And you're back to the truth is courts are ruling with their heart. Some examples are, if you have an image of somebody and you've changed it in a certain way that a court thinks you've changed it enough that the court thinks is ruled with their heart is okay, they will then go, oh, it's transformative and therefore you're allowed to do it. And this is going to come up in the metaverse in a very big way. So, and this is, the AI is going to, wow, how much do you have to change Tom Cruise in order to make him transformative, in order to put him in a film? That is going to be a very, very key issue going forward because of the ability to manipulate, granular on AI. So those are the big defenses. The last defense, which is very important, is and it's an implied defense, but it's implied consent, which is, so I'll give you a couple of examples. And let's assume that an actor in a movie, the studio takes his image and puts it in an advertisement for the movie, and the actor goes, oh my God, I'm going to sue you for right of publicity because you've used my image in this advertisement for the film. And let's assume that there's either no contract or the contract just says, literally just says that the studio can use him as an actor in the film, doesn't mention advertising. The answer is implied consent. Standard industry practice. Everyone knows if you're in a movie, then you're going to be in an ad for that movie. So that's clearly implied consent, even if the contract doesn't say it. Another interesting one is Girls Gone Wild, where girls, for reasons that are not entirely clear, go flash their breasts in public, and somebody obviously films it, and then they end up on the cover of Girls Gone Wild, and they sue over that. Some courts have held, hey, free game, if you're flashing in public, then there's implied consent to the use of that by whoever sees it and copies and videos it. I really think that goes too far, but courts have in fact held that, and have held that was implied consent. So to summarize, if you're using somebody's image directly or indirectly, some vision, whether it's a direct copying or some reference to them, think through the defenses. You got to say, okay, and hopefully the big one is First Amendment, but there's a lot of Public interest is the safe one. Parodies is pretty safe. Transformative is kind of rule with your heart. Next, all right, what another thing that you can't put in your film? You cannot defame people in your film. You cannot do defamation. And defamation is when you assert false facts that a reasonable person would find offensive about a living person. So you can defame someone who's dead all you want, but if they're living, no, it's got to be false, it's got to be offensive, and they've got to be the plaintiff's got to be alive. Interesting aspects to this. I'll tell you a couple of interesting cases. One is the Hurt Locker, where it portrayed a soldier in Iraq, and the soldiers sued and said, by God, that's defamatory because I didn't like a particular way you said this and this and this. And the court said, get a life. This film was actually very complimentary about you, and no reasonable person would have found it overall offensive. And so the guy lost. So that was hinging on the offensive aspect of that. Another one, a lot of cases have got away with disclaimers. So what they go with, they have some pretty bad stuff in the film, and at the end it says, "Just kidding, this is fictional." And courts have allowed that, which is surprising, but disclaimers have worked. And I always tell clients, put the disclaimer in the front of the film, say this is a fictionalized work. But some courts have allowed it even at the back in the end credits, which again I find surprising. Another interesting issue on this is defaming public figures. If the defamation relates to a public figure, the courts require that the falsity be either knowing or reckless. It can't just be negligent. And the classic example here is, of course, the Amber Heard and Johnny Depp case. And he had a very tough threat. He's a public figure, and so he had to prove that Amber Heard either was reckless or knowing that statements that she made were false. And obviously the jury found that was the case. However, this is why he is not suing various publications that said the same thing, because he knew that they would be able to rely on the defense of we're not negligent, we're not reckless. We relied on that Amber Heard said it, and therefore we just were copying that, and somebody told us, and blah blah blah. That's why he did. That's the very reason he didn't sue them. It's very high threshold. They have to prove reckless or knowing defamation. Similar to defamation is trade libel. This is another thing you cannot do in your film. I've talked about trademarks. Trademarks is fine. You Taco Bell, Mercedes, whatever, Coca-Cola. But what you can't do is imply or state false, nasty things about the product being used as intended. So if I drink a can of Coke and it's a regular can off the shelf, and I die and I go, and I roll over and die, and I claim that it's poison, that's trade libel, and they can sue me. So you don't want to do that. And a lot of cases, companies have sued over this issue, and it always boils down to, was it being used in the manner that the product was supposed to? So if I take the Coke can and I throw it at my friend and hit his head, right, and that's okay, because I'm not using the product as intended, right? I'm doing something dumb with it. So that's allowed, and most cases uphold it. But now, when there's an interesting one on this, just as a not in the film, but the way you're really going to see this in a very big way is dear Mike Lindell, Mr. Pillow Guy, against Smartmatics and the voting machines, because he is without question stating false, nasty things about the way they were used in the as intended, which is as a voting machine. And he does not realize, he keeps running around saying First Amendment, freedom of speech, and he does not realize, no, you didn't read Sky's article, because this is one of the things you can't do, which is trade libel. And you are, by the way, Mike Lindell, doing it in a very big way, and you're about to find out a rather big judgment, just the way Alex Jones just got $1 billion judgment for defamation. My guess is that dear Mr. Mike Lindell is going to get $1 billion judgment for trade libel, and he'll have to learn that the First Amendment has limits, and we're going to talk about some of those limits in addition to this. What I'm going through are in fact limits to the First Amendment. These are limits on free speech, and these are things you cannot do, and he's going to learn it. Next, what else can't you do in your film? Well, you can't do obscenity. And what is obscenity? Obscenity it's pornography that violates, and this is the problem, contemporary community standards and has no serious literary, artistic, or political value. So basically, and the problem, the court famously said, this is I know pornography when I see it, the eye of the beholder. The problem is it's a community standard, it's local. And therefore, it's not a national standard, it's a local standard, and you can get sued in, Kalamazoo because they think what you did was too obscene, and you can lose in Kalamazoo, even if you would have won in New York and Los Angeles or anywhere else in the country. And when you got a national film or a national internet reach, streaming, whatever, that's a risk. It's a very serious risk. So what most people try to do is come up with some or literary, political, some commentary that makes it protected as under as kind of free speech, but you can't just do pure pornography, pure obscenity, as defined obscenity. Next, you can't do obviously child pornography, whether or not it's obscene, because it's by definition obscene. And the one warning I would give you on this is that there's a statute that criminalizes even using someone over 18 pretending to be under 18 in a sex scene if that person has some vulnerabilities, like either mental or other or physical or otherwise. The court threw out just if it's an adult and you're pretending that they're a minor, that's the Supreme Court, that's okay, unless, but then they changed the law and they said, well, but if the person has some kind of vulnerability, you're at risk. So just warning to people, look out for that. Let's talk about other things that you can't do, but I'm gonna now broaden it, because to not just films, I'm going to include internet. This could be streaming, social media, videos, YouTube, Twitter, blah blah blah, because it's a lot of people start there and work their way up. So here's things that you cannot do, and this is really a speech to dear Mr. Elon Musk, because he tends to think that there's no limits on free speech, and he might want to think about that. So here's other things that you cannot do, whether it's in a film or any other context. Revenge porn. Many states have laws against revenge porn, so you can't go post pictures of former lovers and without their consent, or do whatever. Incitement to violence. You're not allowed to put on film or media or any other thing is something that is intended to incite violence. And oh, by the way, yesterday or 2 days ago, Oath Keepers just found that out by getting a sedition conspiracy judgment against them for exactly that. And what they were doing was inciting. They were, in part, what the conviction in part was based on was all the messages where they were clearly attempting to incite violence. And oh, by the way, this is going to be what's going to be the big key for Mr. Trump was that whole speech given right before the insurrection, in particular, the Giuliani's comment about trial by combat and the other things that seemed, that were, to me, that was an immediate incitement to violence, which is not permitted, so this is going to be a very interesting, that's where that's going, by the way. It's this aspect of what you can't do. Next, you can't threaten people. You can't threaten violence against people or encourage others to do, where this comes up is the Ku Klux Klan burning a cross. And that is obviously a threat against minorities and is therefore unlawful. And so it's that kind of, it's visual images, but also obviously talk, but it's not just talk. It can be any kind of thing that is, if one way or another, threatening to individuals or to groups. Next, you can't, another things you can't put in your film and can't disclose and can't, no free speech. Classified government documents. Oh, by the way, Mr. Trump may learn about that one too. Medical records, identity of victims, particular minors, embarrassing private information. This is invasion of privacy. Attorney-client privileged information. There's a lot of information that you're just not allowed to disseminate, put online in any other way, or even in Trump's case, keep. And last but not least, which is an interesting, what you can't do is fraud. And fraud is generally viewed as you're saying something that is false and intended to get somebody to rely on it. So obviously turning over money, but the easy one is your perjury, asking somebody to turn over money, something that yelling fire in a theater when there's no fire, is you're getting people to take action, jump out of their seats and cause havoc. What is interesting to me about this, and this is the limits of the First Amendment, is all these whack job conspiracy theories online. And to me, that's fraud. And the people, there is an intent to get people to do something. Insurrection, stop the steal, the people somehow or other take action against the Hollywood pedophiles, take action. This is the QAnon craziness. I think that you could block all of that under this concept of fraud is not permitted under the First Amendment. I think that all these whack job conspiracy theories online is attempting to get people to take some kind of action detrimentally rely on it. And whether it's not getting vaccinated, it's going to the insurrection, it's marching to protest the Democratic pedophiles. So I would have blocked. I think this may go to the Supreme Court. I think that people could bring a claim against it and shove it under the fraud exception to the First Amendment. Okay, so I would be careful of putting fraud in your film. Let me say false statements in your film. So I would expand fraud to include any false statements, because by definition, if you're making a false statement, you're trying to get the person to do something. But that's just me. That's clearly broader. This is right now. I will tell you right now, you can do all the conspiracy theories you want online. God knows why. And it's freedom of speech, and that I don't like. Next, last thing I want to warn you about is what I just did was I did the United States. And oh, by the way, we're just a little country compared to the rest of the world, and the rest of the world doesn't give a hoot about free speech, and most countries don't have any concept of it at all, and they don't like a lot of things. So, you got to look out for putting in your film things that foreign countries don't like, or just accept that they are not going to show it, that they're just not going to permit it, is what's going to happen. Unless You've got an internet site that automatically goes to those countries, and then you can't stop it, and then you're in trouble. Many countries do not care that you're, I'm just a passive internet site. No, by the way, people have posted stuff that you and your foreign country don't like. That's a problem. Companies are learning this in a big way. The summary of this is to be sued is to lose. The last thing you want to do is be sued. And that's why I give this speech to clients, and I'll give it to you, which is, when in doubt, leave it out, right? When in doubt, leave it out, because you don't want to get sued unless you really want to make a point, you want to push the boundary, you're willing to be sued, or for sure based on these rules that you're okay, all right? That you clearly fit within a clearly defined defense, and you're willing to do that. And with that, we now go to the PR portion of the program. And the PR portion of the program is, I'm going to tell you a few things that to make suggestions to you. The first is, if you're interested in this topic or anything else on the entertainment industry, I highly suggest that you get my book, The Biz. It's on Amazon. It's not expensive, and it's a great overview of the industry from beginning to end, including everything we discussed today, but including financing and making your movie and distribution and security laws and trademark, copyright, on and on. So it's a great overall source. I used it as a textbook for a UCLA class I taught for years and years and years, and it's a very popular book. So I suggest that. Second is, I do have a YouTube channel. If you go on YouTube and you search my name, Sky, which is what I go by, Sky Moore. I think if you put in the word attorney or entertainment or film or something, you will find my channel, and it's got it's my entire course that I used to teach at UCLA. So if you're interested, you can do that. I also have a monthly Forbes article. I write a column for Forbes, and it comes out every month. I put it online and I send it. I also send that, and I send out a newsletter every month, including that Forbes article. And if you'd like to be added to my newsletter, it's quite easy. All you have to do is pop me an email with the word add in the subject line. That's all you need to do. And I will add you to my newsletter. And my email address is smoore, M-O-O-R-E, very easy, smoore@ggfirm.com. And GG is just the letters ggfirm.com. And if you send me an email, I will be honored to add you to my newsletter. And with that, I'm going to take questions, because questions are always fun. And if I can figure out, there they are. I got a whole bunch. Okay, so I'm gonna start at the top. And the first question is the information shared here UK, EU specific? And the answer is no. What I did is I answered based on US law, and I did not go, and that's the important, that's why I said at the end, this is not foreign countries. Each one has their own crazy rules, and you got to look out for it. So no. Someone asked the same question. If I write a movie and within the main plot of the movie, there is a reference to a famous play by a deceased playwright, can I mention the play? Yes, you can absolutely mention the play, no problem. Can I have the actors rehearse lines from the play? That's going to be fair use, all right? So if you have actors in your movie read line, and I have this, you may be a client. I had this exact question, and the answer, I think it's fair use. In other words, you're not rehashing the play. What you're doing is, it's in part of your movie. You're saying your characters are just part of it, or reading this, pretending that they're practicing for a play or in the play. And so I think that that's going to be fine. Yes. I think that I hereby rule that's fair use, but you're at risk, because a court's going to rule with their heart, and who knows which heart you get from a judge. Yeah, it's exactly, it's a great question. That's a fair use question. All right, next. How do you clear scholarly translations of an older work in the public domain? For example, an English translation, translations. Copy, the translation is itself a copyrighted work. You can't, short answer is, you do your own translation. If you can go back to the work, to the foreign language work that's in a foreign language and it's in public domain, have at it, but you've got to do your own translation. If you rely on someone's translation, and that, because the translation itself will be copyrighted, so you can't do that. Can I use footage in my film of a city location without a city permit? Yes, you can. There are, copyright. Okay, clearly no copyright, clearly no trademark. Can a city request a permit to film? Yes, if you're doing like a studio shoot and you got a bunch of crew, but if you're just out there filming, and you will not need a permit if you are out there just with your own video camera, your own whatever videoing, and you don't have a crew. That's different if you have a crew. Next, what if someone says we should do a movie on a public figure and then send the script, but it's not good? So we then go and do a totally different story take on the same public figure. Have at it. All right, so I get it. So someone submitted an idea. Hey, let's do a film on X, and you go do something else. Well, first of all, you have the right to do it. No right of publicity, that's for sure. You may get a claim though by that person for, this is the idea submission case. Will you get a claim for misappropriation? And I'm assuming you didn't solicit it, so you don't have an implied contract claim, but you may get a claim for, hey, you stole my idea. And most of those cases lose, but some win, so you got to be careful. I read registration with the WGA is useless. You probably read that from me because it is useless. I keep telling people that. But is getting an official copyright necessary? No, you do not need to register if you write something, you're protected. All you have to do is show that you wrote it and when you wrote it, but you don't need to register it with the WGA or the copyright. Just date it, all right? And if you submit it, obviously it's in writing. So if you've submitted it, clearly it's in writing. I talk about fair use for feature documentary or documentaries. Fair use applies to anything. Applies to film, documentary, internet, whatever. Next, a true story, now publicly known, happened in 1977 that a journalist experienced, wrote about in a newspaper. I've optioned the life rights of the journalist to turn the experience into a movie. Do I also need to option the article from the newspaper? You didn't need to do anything, goofball. Whoever did this, you're like all my other clients that keep running around paying everybody for factual information. Go read my Forbes article, Schuyler Moore, search Google Schuyler Moore. Why are you paying for factual information? You don't need to do it. It's by definition, if it's an article, it's public interest, have at it. You don't need to pay the author. You don't need to pay whoever's in it. You don't need to pay the newspaper. Stop. All these people running. I had one client pay like 5 different newspapers because they all wrote about the same story. And it was like, this was Snowden. Snowden is public. Hello. You don't, so someone wrote about it. So what? Does this mean companies like Film Freeway, who have screenwriting contests, cannot use my submission? It depends what your submission agreement says. I haven't read their submission agreement, so be careful, read it. But if it doesn't say anything about it, then nobody can use it. If just submitting it alone will not put your film, your screenplay in the public domain, unless the terms of use say that, buried, and be careful because they'll probably have some click-through license that has a lot of stuff in it. So be very careful. News footage, can't use news footage. News footage is copyrighted. and you got to be careful. You can, unless you're going to rely on fair use, and good luck. Okay, because that is courts with their rule with their heart. And this comes up all the time. People get sued. By the way, news companies get sued for using other companies' news footage. So you got to be very careful about it. Again, can you use ideas from a story you see in a newspaper? If you don't use real people, but the concept. By the way, you can use the real people. All right, you can make your, and obviously make us. You read a story about Joe Blow. You can make your movie about Joe Blow using an actor playing Joe Blow. You don't need to change the name. You don't need to pay the newspaper. You don't need to pay anybody. Next. Marcus Garvey is a famous Black hero in history. He died in the 40s, but his organization he began, the UNA, still exists. Can we tell a story that includes him and his organization in the original screenplay without his permission or his ancestors? Yes, James. This is from James. Yes, James, have at it. He's clearly a public figure. You can do whatever I mean, this is, if he's, you telling me he's famous. If he's famous, have at it. You don't need his permission. You don't need his organizations. You can use his name. You can do whatever you want. And I want everyone to go do this because it's driving me crazy that I keep getting clients that can't do this. News footage. Can I use YouTube footage for a documentary? Woof. The YouTube footage, whoever shot it is going to have copyright protection. So you're going to be relying on fair use. And again, that's a rule with your heart question. So technically you can't unless you're willing to rely on fair use, and just be careful. Where does fair use come in on copyrighted materials? I think I've answered that pretty well. I know this is for film, but do these rules also apply if you use a photo on YouTube? The rules that I just gave apply across, that's why I did it, apply across the board. YouTube, Twitter, Facebook, anything. The rules that I just gave apply across the board, absolutely. So what happened to Warhol? The answer to Warhol is up in the Supreme Court, and you're going to keep an eye on this. And it was I couldn't believe that the Supreme Court took the case, because they last did a very important case on this called Google versus Oracle. And they gave a huge 30-page opinion that said a bunch of garbage and said nothing. And they ruled with their heart in favor of Google, even though it was an absolute blatant copyright infringement. I can't believe they took another fair use case, because the truth is I keep waiting for them to write an opinion that says, you know what, we rule with our heart, and that's the end of it. But they won't do that. What you are going to see when that opinion comes out is you're going to say one of those two things, transformative, blah, 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 or not transformative, blah, 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 blah. That's what you're going to see. And then lots of stupid words. What if you use references to another film? Yeah, you can use references to another film. That's fine. Or similar looks. You got me concerned when you say, can you use similar looks? Yeah, that's a copyright. That's an indirect use. That's a derivative work. So is it too close to, is it similar enough to be derivative? Mm-hmm. And if so, do you have fair use? Okay. So that'll be your questions. I'm next. I'm writing a story about a well-known radio broadcaster who's dead. He wrote a memoir that his his widow will not let me option. Here we go. I've done interviews, blah, blah, blah. Can I use my interviews and what I research on the web, film or TV, about a well-known, I'm going to interpret well-known as famous and therefore public interest. And I hereby rule that you can do whatever you want, right? In a book so now the interviews, you say, can I use interviews? That's going to be a right of publicity question as to, did you get clearances from the people that you interviewed? Or are you going to rely on implied consent? So let's say you go to somebody and say, hey, can I video you and talk about blah, blah, blah? And they go, yeah, you can video me. And that's, now the question is, can you use that interview in your film or documentary? And the answer is probably yes, because if you look at the Girls Gone Wild case, that's implied consent. And what does the person think you're going to do with this video? probably put it in a documentary. So the interviews, you're probably okay. Famous, you're probably okay. Tell the widow, the poor widow, to go jump in a lake. You don't need to option the book. It's public interest. And tell them Sky said it. So everyone's driving me crazy on this. I am producing a TV series promoting actors, and I want to show some of their prior work as I introduce them. Can I show clips of that work? Or if not, can I show a still from that work? Okay, that's copyright. We now have a direct copyright use, and you are going to be relying on fair use. And so I'm going to rule with my heart and say you can do it. And another court may, and a judge may rule with their heart and say you can't. All right. So there's no firm rule on this. This is a fair use. That is a fair use question. And I mean, can you use a clip? And by the way, people, short answer is people do it all the time. I see this done all the time. And I doubt that there are people running around getting consent from the companies because it's too hard to get clip right clearance. It's way too hard. So everyone tends to rely on fair use, and I would be surprised if the owner of the copyright would sue over that kind of use. I would love a recording of this, says somebody very kind. This is extremely helpful. Yes, the IFTA is recording this. This will be available for later use, and you can bore all your friends by showing this to them. If you are shooting a commercial or still for a commercial and feature public art in a mural on the side of a building. Oh boy, that one. Additionally, a mural on the side of a building can be copyrighted. Graffiti can be copyrighted. You are now asking a fair use question. And in fact, commercials have been sued for exactly this and have lost because they prominently featured the graffiti. They intentionally put the car next to a wall with fantastic art, and the artist sued and said, haha, tangible medium of expression, and the company said fair use, and the court said no, I don't think that's fair. So that's the answer to this, is that this one is cases have lost on this precise question that you are asking, Mr. Phil. So Phil, if you search, you will find cases on this exact point. How does fair use hold up for documentary and educational films? It holds up great, depending on what you're doing. It totally depends on what you're doing and what the facts are and how close and how much use you're using. But it does, it applies. It applies. It just, what do you do? What problems do I encounter if I write a spec script on a copyright property, and I submit it to the copyright holder for consideration? There is no copyright claim since it is not produced. No, I have clients that do this all the time. You see a film and you go, I've got a great idea for a sequel, and you write the idea for the sequel and you send it to the film company. You are protected, all right? Now you can't go do that, whatever it is that you wrote, because you're clearly infringing the original. You're doing a derivative work, and I don't think that's going to be fair use. But the film company can't use your idea either, all right? Because you have a copyright in the new elements that you added to your screenplay, and therefore film company cannot use that. And if they do, you are going to have a very good copyright claim. And so you should hope that they go use it and don't pay you, because you will have a great claim. Can I use a pre-1926 recording of a song, since copyright should have expired and I should have it recorded by, and can I have it re-recorded? Music is its own weird world. I'm going to be careful about pre-1926 recordings. It's either in the public domain or it's not. If it's in public domain, have at it. But I'm worried you've obviously looked at this and say, use the word should, and should is not, I don't know. The short answer is I'd have to go look at is pre-26 recordings, are they in the public domain or not? But if they're not, you can't do it, all right? If they're not, you can't do it. How do I draw a line between an idea, which is not copyright, and the expression of it, which is, so somebody's asking the question. In other words, what the person is asking and is, you're allowed to use the idea of an original work in creating a new work, and that's not copyright infringement. But if you use the expression, then it is infringement. The short answer is courts rule with their heart, and then they add the words. So here's what's going to happen. If they think it's too close, they're going to say, you use the expression. And if they think it's far enough apart, they're going to say, you just use the idea. And so it's part of this. The truth is they rule with their heart, and then they add a bunch of words. And if they like what you do, the word will be idea. It will be fair use. It will be transformative. And if they don't like what you do, the words in the decision will say expression, too close, not transformative, but it's all rationale. The truth is they rule with their heart. What about true stories like from the 1800s and more recent? Well, true stories, have at it. Come on, I don't have at it. I don't know. You put it in quotes, so I don't know what that means. But if it's a true story, it's a true story. Then you can do what you want. Recording. IFTA puts up the recording, I think, within a week, if I remember. Can you tell us how I deal with orphan rights? Well, if I knew what an orphan right was, I don't know what an orphan right is. I don't know what you're referring to exactly with an orphan right. So you can make me send another question explaining how you're interpreting that, because I can interpret that in different ways. Can a clip of a documentary film be used in another documentary film under fair use? 5 to 10 seconds. Fair use. 5 to 10 seconds. I hereby rule that it is transformative. And okay, no, it's fair use. Who knows what a court will do? Who knows? 5 to 10 seconds. I think you're okay. But again, you're in risk land, of course. Right, working on a script where at one point a real life person appears, where real life person have written the role as blank. Somebody, film director, is in case the individual declines to appear. I don't really understand that. Where real life person appears. Well, I don't really understand. With apologies, I don't understand the question. If a real life person knows they're being recorded, then you have implied consent, and then you should be okay. If I don't know, so if you've just secretly filmed them and they're putting them in, then that's the right of publicity and no implied consent, and now you're down to the conflict between some cases hold that its expressive work is protected and some say it has to be transformative for right of publicity. So you have to clarify what you're doing there. Is there a statute of limitations for a painting such as, yes, absolutely, Monet is in the public domain. You're certainly allowed to put Monet in the film. The oldest copyright is like 95 years. And before 95 years, your public domain, you can do whatever you want. So that's another, I should say that. So it's no longer protected by copyright. So then you're absolutely free to do it. Excuse me. Would the Salvador Dali mustaches on Da Vinci? Someone's asking a similar question. What if Dali does? Well, Da Vinci, he's. Short answer is if you're mucking up some prior work, is that fair use? And the answer is, yeah, depends. What's a court going to rule at their heart? Do they like it or not? And this is a rule. That's a fair use question. That is a rule with your heart question. And now you know the answer to that, which is what will a husband do? Okay, someone just telling me that they had fun with their ex-husband and won 10 awards on a screenplay. Congratulations. Okay, which I don't see a question there. And is the fair use analysis the same for documentaries? Yes. Yes, it is. It's exactly the same. They rule with their heart. So use of data derivative. So AI use of, this is a fun one. AI, I have an article. The way AI works is you feed it a bunch of existing factual information, including a lot of copyrighted material or real images, and it spits out something new that's either a new copyright work or a new image. And the question is, can the original owner of the copyright or the image sue? There's lawsuits going on right now on that precise question, and I believe it's a fair use question. And I believe that it will be allowed, that the use will be allowed, the claim will fail, and I believe that fair use, it'll either be treated as, the wording that you will see is no, just the idea, or more transformative, and therefore fair use. You're going to see that. But this AI question is coming up, and I have an article on this in Forbes on this that talks about it in detail, so you can find it. Search Schuyler Moore, Forbes, artificial intelligence, and you will find my article on this precise question. Same question about the statute of limitations for music like the Beatles. Beatles is not, that's clearly copyrighted. They're not even close to the statute of limitations. I like to have my actors singing Beatles music. Whoa, but my understanding is it would cost me a lot. Yes. Is there a time limit? Yeah. If you wait about 95 years, you'll be able to use the Beatles. Okay. How do you establish public domain? Public domain is, the work has to have expired. So, you're 95 years. That's the general rule. Can I guess here? Sky, can you define what you mean by transformative? Yes, I can. It means nothing. It is garbage wording that courts put at the end of the decision. And I cannot emphasize this enough. The courts will rule with their heart, and then they will just add a bunch of words. And if they like what you do, their word will be transformative. And if they don't like what you do, the word will be, you use the expression of the idea and it's not transformative. But I tell you, I swear to you, they rule with their heart and the rest is idiotic. How does one go about making a documentary that shows examples that help define the thesis that would be transformative for education? That I don't understand I don't understand the question. Don't understand the question. I wrote a screenplay on a shooting I was in Oakland, and as an Oakland policeman. Can I use Oakland police patches on my uniform? Yes, absolutely. This is a trademark question, and yes, you absolutely can use Oakland police patches, whether or not, by the way, you were an Oakland policeman, because that's think in a movie you see patches all the time. Yet it's a trademark question. You're not implying that the Oakland police made that film, and therefore you're not confusing the consumer as to the source of the good, and therefore you're fine. You're good to go. Okay. If you're in a public places and things are on display while shooting, does this protect you from infringement or copyright? No. This is a problem. This is why clearance. This is why if you look in the back and you see something that I did, let's say I'm in a movie and you go, oh, look, there's a picture that Sky did. That's a problem. That's and now fair use. All right. it's short and it's in the back and it's fuzzy and it's whatever. Hopefully that's fair use. But it's a prima facie copyright claim. And then the question will become fair use. Is all footage from the World War II archives available for fair use in a documentary? No. It depends. It depends. So a lot of World War II footage is still protected by copyright. The 95 years hasn't expired, and so you generally need clearance to use it. You generally need, unless somebody has dedicated it to the public domain, like the government, but you have to go check with the source. Okay. If a book was written before copyright, is it okay to use references, names, ideas? Yeah, well, absolutely. Even if a book was written with copyright, it's fine to use references, names, ideas. Facts, you can use facts. This drives me crazy. You can use fax. You don't need to pay people to use fax. Okay, stop. All of you guys, stop paying people to use fax. Okay, I have a shopping contract, but he says that if I close to get production, he will sue me. I've spent 20 years on this. I've always included him in the copyright. He would receive 1/2 of the selling price. I don't see a question. If you want to ask a question, put a question mark and ask me a question. If you have an idea and you ask someone to write a script based on the idea, but ultimately you don't use that script, are you liable to the original writer for any similarities in the final version? If you have an idea, but ultimately you don't use the script, are you liable to the writer for any? Oh, well, yeah. Yes, you could be. So what I'm taking it you did, you hired someone to write a script, but you were a goofball and you didn't get an assignment of copyright. That's how I'm interpreting this question. I am a Hollywood producer that does the typical dumb thing of hiring somebody to write and not making it a work made for hire, which, by the way, is like the dumbest thing in the world. So if moral to the story is, hello, you're hiring someone to write, you better put in contract that it's a work made for hire and you own it, like duh, okay? And now you've gone off and done something else that's used something in his version, you're in potential trouble. If you don't have if it wasn't an assignment or a work made for hire and you're using somebody else's, script, yeah, okay, yeah, you got a problem. Unless you're going to argue fair use or it's too transformative, whatever. When you're using a trademarked item, does it matter if the content topic of the film may have negative themes? No, it doesn't. So I'm going to drink my Coke can and I'm going to shoot up heroin and then die of heroin. I'm going to go rob a bank holding my Coke can. Totally fine. That's not trademark it's not trade libel because you're using the Coke in the normal way and you're not implying anything negative about the Coke can. So the short answer to your question is absolutely not a problem. If the new Sex in the City Mr. Big character dies while working out on a Peloton bike, yes, Peloton stocks dropped. Can Peloton sue the production company? No. Short answer is no. It wasn't the bike. If the bicycle caught up on his leg and killed him because it ripped his leg apart, that would be trade libel. But what happened in that scene, it was a famous scene, is the guy just died because he was, had a heart attack. That's not Peloton's problem. And no, they could not sue. Next, do parents actually have the right to sign release forms for their children? Can't the child sue when they're old enough? Not in California, and not if you go to court and get, short answer to your question is signing a loan, parents have no right to sign for their children unless you go to court and get approval. And that's only in California. Other states don't have that rule. So parents do not have the right to sign for their children. Hello, I have a question. My music editor and musician made a short melody of my short film, which motifs inspired by blah, 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 cycle, which inspired background sound of the character. I don't see a question mark. So somebody used something, but they don't ask a question. And they got too many weird things in there that I can't even figure out. Many broadcasters and production companies require signed submission waivers, yes, before accepting submissions. How do such submissions requirement protect companies? How does the material owner? Okay. So this is a very common question. Because of all these problems, film companies typically make people sign a submission agreement. And what the submission agreement basically says is, we already own this and we can do whatever we want. If I were you, I would not have that contract reviewed by a lawyer, and I would just sign it and I would send it in with my work. And I would hope that they use it, because there's an important case that held that submission agreement violated, was invalid because it violated public policy, because it was just too stupid. It literally said that and it was in that case a toy company, and the submission agreement said that the toy company could do whatever they want, and they did, and the submittor sued and won and held that waiver was invalid. So yeah, as long as you don't have it reviewed by a lawyer, and you just send in your thing, you're probably going to be okay. But by the way, they're just going to put whatever you write, send in the trash anyway. So it really doesn't matter, because film companies don't take random submissions. They routinely put them in the trash. That's just not the way the industry works. The industry works by people who have clout calling up and can talk to the guy, and it's connections. It's not random submissions will not get listened to. Will I do a webinar about potential VR metaverse legal considerations? I did it. IFTA's got it. I also have articles on this, on these topics. If you go search Schuyler Moore, Forbes, and go metaverse and virtual reality, I've got big articles on both of those. So you can get everything you want about metaverse and VR on my Forbes articles. I also did a IFTA seminar that touched on producing for that kind of content. If I drone a public event, can I use the B-roll in my film? Absolutely, that's going to be fine, because anybody that appears in it will be incidental. Write a publicity claim, but incidental use, so you'll be fine. What if I submitted a fully developed idea to a production company about a historical figure, and they take your title and do their own version? Yeah. As long as they do their own version, they're fine, because you're telling me it's about a historical figure. So you can't send in a script about George Washington and hope that you're going to stop the film company from doing any other film about George Washington. That's not going to happen. All right. So, but they can't use your script. And if they do something that's too close to your script, you're going to have a copyright claim, and then it'll be that the normal rule with their heart routine, which is is it idea versus expression and blah blah blah. Can a written agreement signed by two parties be considered binding and hold good in court? That's a very funny question. Can a written agreement signed and dated by two parties be binding and hold good in court? It better be. That's what the definition of a contract is. So I would hope that would that would be, depending on what it says, of course. I mean, then the question is, what does the contract say? If it says something dumb, then maybe it won't. Okay. The motion to dismiss the infringement claim by the authors of the blah, blah, blah. Okay, this, was denied. The motion to dismiss the infringement claim. I don't know the details. So I know the question. I know this question. This is the Top Gun question. I think the claim is merit. The short answer to that question is I'm familiar with the facts. It's complex, but I think the claim absolutely has merit. In the case of a documentary shooting within a public event, is a public announcement about the shooting inviting those who do not wish to be shot to move to a specifically reserved valid as a release of those on camera? I wouldn't worry. If it's a public event, I wouldn't even worry about it. It's just like, it's incident. You got the incidental use. You're asking to write a publicity claim. That's an incidental use defense. So I just wouldn't even worry about it. But I don't think that telling people to move is a valid defense or is a valid release. I think that's kind of silly. Is it published on the internet enough to be public interest? Depends what it's maybe. It's who's publishing it. Was it a news source? Who published it? If I published something, about my friend Jack, no, that's not. So it depends what it was that was put on the internet, not and who put it up. Could a celebrity protect himself from a deep fake by registering his name and image as a trademark? No, I don't think that would work, because trademarks are not protected automatically unless there's consumer confusion as to the source of the goods. And so the person would have to then say, not only am I you're using my image, but you're making people think that it came from me. And I just, the fact that you've got somebody, Brad Pitt in a film doesn't mean that people think that he produced the film. So no, I don't think that gives you protection. Can a writer name a character in a film Tom Cruise, but cast someone who looks very unlike Tom Cruise to play the character? Character would have a very different personality than that of the real, but not defamatory. It would just be for a laugh. If it's a laugh, it's parody, and that parody is a protection against the right of publicity claim. That's one of the defenses that I mentioned. So I think as long as it's funny, you've got, you've probably got the parody defense. Otherwise, I think just using the name, I don't know. It's a right of publicity claim, but I don't think it's. I just, it's one of those things that I just don't think a court would rule. It's kind of like a fair use defense, but although there's technically no fair use on a right of publicity claim, the courts tend to do the same result, but call it something else. If we create a film based on someone's personal life story with that person's consent, can other people portrayed in the film, other family members sue? The answer to that is it depends if it's it depends if it's public interest or not. If you do a story about Martin Luther King and you drag in relatives, friends, whatever, that's okay. The courts have held that's okay. But if you do a story about, me, all right, and I'm not a public figure, and you drag in my wife and family or God knows what, no, they're going to have I will have a valid claim, but if I consent, the other people will have a valid claim. Yes, they will, because they weren't connected to a public figure. We've now gone for an hour and a half. I've had great fun. And I appreciate everybody that hung in this long. And with that, we're gonna call it, because I was given an hour and a half time period, and I think that have I done it? Yes, I think I've done it. Okay.
Thank you, Schuyler. We are going to have a recording of this. We will make available early next week. We will also provide in the email when we send each of you the recording a link where you can fill out for MCLE credit if anyone listening in is a California lawyer. And thank you so much for your time, Schuyler. This has been terrific.
My pleasure.